This webinar is a basic overview of trademarks, which is one form of intellectual property. What is intellectual property? It consists of four basic areas: trademarks, copyrights, trade secrets, and patents. So what is a trademark? A trademark can be a word, it can be the name of an individual, it can be a symbol like the Nike swoosh, it can be a design like the Apple logo, it can be a slogan such as "Just do it." A trademark can be a distinctive sound. For example, the Harley-Davidson's twin-engine sound is protected by a trademark, as well as the NBC chimes. It can be a color. For example, Home Depot has protected the color orange. John Deere has protection for the colors green and yellow. And the Post-it shade of canary yellow is trademarked by 3M. A trademark can be a product shape, such as the Coca-Cola bottle, and it can even be a scent. Chanel perfume is protected by a trademark. So a trademark identifies and distinguishes the goods and services of one seller or manufacturer from those of another. Here are some trademark examples which I'm sure you will recognize. There are four different types of marks. Trademarks are brand names for products. For example, Pepsi for soda. Service marks are brand names for services. Think McDonald's for restaurant services. Certification marks indicate that certain standards have been met. For example, UL certified. And finally, collective marks identify members, services, or goods of a group. For example, Teamsters Union. So why are trademarks important? Well, they're an intellectual property right. They can be valuable corporate assets used to gain commercial advantage over competitors. Did you know that the Apple brand is worth $145 billion and the Google brand is valued at $66 billion? Trademarks represent quality and provide consumer recognition. They help to maintain a reputation among customers and competitors. But most importantly, trademarks represent a brand promise. When selecting a mark, you want to consider a variety of factors. First, the distinctiveness of the mark. Second, you want to consider the brand promise associated with the mark. You want to consider whether the mark is easily remembered or pronounced, and you want to make sure that there are no adverse foreign or slang meanings associated with a mark. Finally, you want to make sure that the mark is legally available for you to adopt and use. When selecting a mark, there are four different categories to consider. The first category are called fanciful marks. These consist of coined words that are previously unknown. For example, Clorox, Polaroid, Kodak, and Xerox are fanciful terms because they are unrelated to the underlying goods and services that the marks are used in connection with. Fanciful marks are preferred because they're the easiest to register and they're strong when a connection is made with consumers. The next category are arbitrary marks. These are marks that comprise words, symbols, or pictures that are in common use, but which, when used with the underlying goods or services, neither suggest or describe any ingredient, quality, or characteristic of the goods or services. Some examples are ivory for soap, Apple for computers, and even Yahoo for an internet portal. The next category are suggestive marks, which are usually registrable. These marks require imagination, thought, and perception to reach a conclusion as to the nature of the goods and services. Suggestive marks imply a characteristic of the product or service. For example, handy strap is suggestive of a stapler strap. The term sparkle is suggestive of window cleaners. And even the term penguin would be suggestive of food freezers. Finally, we have descriptive marks. Descriptive marks are difficult to protect. They describe the intended purpose, function, or use of the goods, the size of the goods, or the class of users. They're not inherently capable of identifying the source of the goods and services. However, they can be registered if secondary meaning is shown by use of the mark over a period of time. An example is big and tall for casual clothing, and even the mark perfect slicer for a fruit and vegetable slicer. This graph shows categories of marks from the weakest to the strongest. At the lower end of the spectrum, we have generic terms. The marks aspirin and escalator were at one time protectable trademarks. However, they are now generic terms. Generic terms are not registrable because they define a class of goods and are needed by competitors to identify their goods and services. Interestingly, Xerox and Kleenex are still protected, but have been teetering on the cusp of genericism for years. And last year, Google's opponents in a court case claimed that the trademark had become generic, so everyone could freely use it without any restriction. The court, however, rejected the challenge and confirmed that Google is a valid and protectable trademark. And as I mentioned previously, it's worth $66 billion. When you are in the beginning stages of selecting a brand name, the first thing you should consider are clearance searches. The purpose of clearance searches is to determine whether the mark is available to use and register in connection with specific goods and services. When determining availability, the basic test of trademark infringement is whether the mark is likely to cause confusion, cause mistake, or deceive consumers based on the prior use or registration of another mark. When conducting clearance searches, several factors are taken into consideration. The first marks to be considered are federally registered or pending marks, which can be found on the United States Patent and Trademark Office website. The second types of marks to consider are common law marks. These are unregistered trademarks. You want to consider company names and also internet usage. Most importantly, you want to obtain a use and registrability opinion from an attorney. This opinion will let you know whether the mark is federally registrable and whether or not it infringes someone else's prior rights in a mark. Remember, just because the Secretary of State's office says that a name is available for incorporation as a trade name or business name does not mean it can be used as a trademark. When considering likelihood of consumer confusion, several factors are taken into consideration. The first factor is similarity of marks based on their sound, meaning, and appearance. The second is similarity in the nature of the goods or services. We then consider similarity of the channels of trade for the respective goods or services, fame of prior marks, the number of similar marks that coexist in the marketplace, whether the goods are impulse purchases or purchased by sophisticated consumers, and whether there is any actual confusion in the marketplace. Here are some examples of marks that are confusingly similar. Beauty Rest versus Beauty Sleep for mattresses, Beer Nuts versus Brew Nuts for nuts, Blue Nun versus Blue Angel for wine, and London Fog versus Smog for raincoats. By contrast, here are examples of marks that are not confusingly similar. After Tan versus Après Sun for after sun lotion, Dawn versus Daylight for detergent, Hard Rock Cafe versus Country Rock Cafe for restaurant services, and Mr. Clean versus Masterful Clean for cleaning products and services. There are two types of trademark rights. The first are common law trademarks. These rights arise out of usage, and they accrue in a geographic territory in which the mark is used. The second type and the stronger rights are federal registration rights. These provide nationwide protection, and they offer significant advantages, such as the presumption of validity at trial if you were to enforce your trademark rights, and they can become incontestable between the 5th and 6th year after registration. So what's involved in the trademark application process? Well, it usually takes between 12 and 18 months. The first step is to file a trademark application with the United States Patent and Trademark Office. When filing an application, you need to determine whether the application will be based on use, the mark is already in use in interstate commerce, or whether you have a bona fide intention to use the mark in the future. After about 6 months, the application is reviewed by an examining attorney at the Trademark Office. They then issue a report describing whether there's a likelihood of confusion with a prior registered or pending mark. They may raise a descriptiveness issue. They may request that you clarify the description of goods and services, and they may even require a disclaimer of a descriptive term. The government gives you 6 months within which to file your response. If all goes well, the application will be published for opposition by third parties, and if no opposition is filed, a registration certificate will issue. So what are the advantages of a federal registration? Well, if you filed an application based on your intent to use the mark in the future, once you have commenced use, your rights go back to that original filing date. These provide national rights in commerce once you will actually use the mark. You have the right to sue in federal court for trademark infringement, and you can record your registration with Customs so that they can police and seize counterfeit goods. Finally, a registration can be used to transfer a domain name. Rights in trademarks are created through proper use of a mark. First, two symbols should be used. If a mark is federally registered, the R in a circle should be appended to the end of the mark. However, if the mark has been adopted and used, but not yet registered, the TM or SM symbol should be used. This puts the public on notice that you consider the mark to be your trademark. It's important to note that incorrect use may contribute to losing a mark. Inconsistent use may dilute a brand, and the mark may become unenforceable against infringers. Improper use can also turn a trademark into a generic term, even if used correctly by the trademark owner. Trademarks can last forever if used properly. As we mentioned before, Google was involved in a lawsuit regarding whether the mark had become a generic term. Google has been working hard to make sure their mark is properly used. The proper use would be the term Google, followed by an R in a circle, and then followed by the descriptive terms search engine. Google doesn't want the public using the phrase, "I'll Google it," because then it would become generic. So how should marks be used? Trademarks can be used directly on the product. Trademarks can be used on the containers or packages for the goods. Service marks can be used in advertisements or brochures for the services. Trademarks or service marks can be used in catalogs, brochures, and manuals. And marks can also be used in displays and on websites. Trademarks can last forever and are perpetual if they're continuously in use. However, once you obtain a federal registration, the government does require that you file a declaration of continuous use between the 5th and 6th year following registration. The government then requires that you file renewal applications every 10 years. It's important that once you have a federally registered trademark, you police that trademark to identify infringers. If you uncover infringers, you want to notify them through a cease and desist letter and possibly litigation to protect your rights. Remember, the standard for infringement is likelihood of confusion or dilution. While remedies include injunctions and phase-out periods over time from an infringer, money damages are difficult to prove. There are two types of trademark infringement. The first type is likelihood of confusion. Is use of a mark likely to cause consumer confusion as to source, sponsorship, or association? The second type is called dilution. Is there an association in the mind of consumers between a mark and a famous version of that mark, regardless of the goods or services? For example, Coca-Cola is considered a famous mark, which allows Coca-Cola to prevent anyone else from using that mark on even unrelated goods. What is trade dress? Well, trade dress originally was the way a product was dressed up or packaged. Most trade dress infringement involves the packaging or labeling of goods. Today, however, the overall image or configuration of a product is protectable if it has acquired secondary meaning. Here are some trade dress examples which I'm sure you'll recognize. In conclusion, you want to identify a mark and determine whether it is important to you and your company. You want to take early action to clear the mark so you avoid any problems with infringement down the line. If the mark is available, you want to file appropriate trademark applications to obtain registrations. And once a registration is obtained, you want to police the mark and pursue infringers. This concludes today's webinar. Thank you for attending.